Estate planning is a crucial topic often overlooked by investors. While as financial advisors, we are commonly associated with investment management and retirement planning, we also view estate planning as vital for a solid financial strategy. That's why it's known as a key domain for certified financial planners. The issue lies in the gap between recognizing the importance of estate planning and taking action. Surprisingly, only a third of adults in the U.S. have documented their end-of-life plans, despite over half acknowledging its significance. Only 32% of Americans have a will. Only 37% of Americans have an advanced medical directive. And over half the people don't know where their parents store their estate planning documents. In this video, I'll discuss crucial estate planning areas that we address with our clients. Every individual has unique circumstances, so I'll speak generally about these topics. This video aims to prompt your consideration and encourage you to reach out for guidance if needed. A quick disclaimer, we're not estate attorneys, and some of the discussed actions should involve them. We understand the nuances, we can help our clients identify gaps and implement the steps that their estate attorneys outline for them, but some of these things require coordination with an estate attorney. Perhaps the biggest myth is what a will accomplishes. Having a will is necessary, but not sufficient for many people. Assets like brokerage and bank accounts that are designated by a will are still going to go through the probate process. You should want to keep as much of your estate out of probate as possible. It's time-consuming, costly, and it also makes your estate a matter of public record. Avoiding probate for your retirement accounts like IRAs and 401ks is relatively straightforward. These accounts enable you to designate primary and contingent beneficiaries, whereby those assets bypass probate and go directly to the inheritor. Brokerage and bank accounts, on the other hand, do not have explicit beneficiary designations. Two common solutions for these types of accounts are to either register those assets under something like a revocable living trust or apply what's called a transfer on death or TOD status to the account. Taking either of these steps should keep those assets out of probate. Next, let's talk about making sure your financial and medical wishes are carried out if you become incapacitated. When it comes to financial accounts, the type of account matters. Accounts that are registered to a trust will follow the direction of the trust document and trustee, and should also specify someone as a co-trustee. The trust document should specify the scope and limitations of the co-trustee's authority. What about accounts that are not in a trust? Retirement accounts and other brokerage or bank accounts will need what's called a power of attorney to be specified, a trusted person who will carry out the wishes of the account owner if they become incapacitated. The account owner can specify the details surrounding when the power of attorney becomes activated and what the limitations of his or her authority may be. Although not necessarily a financial question, creating advanced medical directives is also part of the estate planning conversation. The two most common advanced medical directives are a living will and a power of attorney for healthcare. The living will is a legal document that tells doctors how you want to be treated if you can't make or communicate your own decisions. This includes which medical treatments you would want, which treatments you would like to avoid, and under which conditions. A durable power of attorney for healthcare names your healthcare proxy. In other words, the person that you want to make healthcare decisions for you if you can't. This video is not a comprehensive summary of estate planning essentials, nor does it even touch on the estate planning needs of a family whose net worth is large enough to be subject to estate and gift taxes. However, the topics that I've just covered are general pointers that virtually everyone should consider. Taking these steps and communicating your plans to trusted friends or family can leave your loved ones in a much better position to handle your affairs at the end of your life. Please contact us if you'd like to discuss these topics in greater detail.